Good afternoon, everyone. Welcome to the webinar. My name is John McDermott, and I work for the Institute for Human Development in Flagstaff, Arizona. We are a university center for excellence in developmental disability, and we're located on Northern Arizona University's campus. I've put a link to our website in the chat area. Come and visit us anytime. I see a lot of familiar names from the earlier webinar that we did, so welcome back to all of you. I just want to remind you that this is a listen-only webinar, and if you have any questions or comments, please utilize the chat pod in the lower right and middle. If it's a question directed at a particular presenter, you can put their name in the chat area too, and at the end when we have our Q&A session, I'll be able to direct that question to them. What you'll see is a whole bunch of pods on your screen. Some of the pods have 4 arrows. You can press those 4 arrows to make that particular pod full screen. And finally today we'll be recording the webinar. We'll be uploading these to our YouTube channel and also the ADDPC's website, so you could share with others who missed the webinar today. At this point I'm going to hand it over to Sarah from the ADDPC. So thank you very much.
Welcome everyone. We're excited you have joined us for our second session today. John's right, I recognize a lot of familiar names, so welcome back. And to those of you who have just joined us, you're in for a treat because we have some great speakers here today. As I mentioned earlier today, we here at the Council get a lot of emails and phone calls regarding the question of guardianship from family members across the state. We know this is a topic that can be confusing, it can be complex, so that's why we wanted to put together some training, some information for families out there who have questions. Let me introduce who our speakers will be today. We're going to start off with Kelly Morris. Kelly is a licensed counselor and a mom to 2 sons. She's navigated the guardianship process alongside her adult son Zachary and her husband Ray, who happens to be the chair of our council. The couple founded an organization called Dads for Special Kids, and it supports fathers who have children with disabilities. Our second speaker will be Jana Murrell. She serves as the Director of Family Support and Education at Raising Special Kids. Jana often gives trainings helping families go through the legal process when their children turns 18. So today's topic is nothing new for her. And then finally we'll hear from Jennifer Kupaszewski. Jennifer works as an attorney at Kyle and Kupaszewski, and she's built her career around Arizona advocating for people affected by disability, abuse, and neglect. So welcome everyone. I'm going to hand over the reins to Kelly. The time is yours.
Thank you very much. I'm really glad to be able to participate in this webinar, and what I want to focus on, because I've sat on both sides. As Sarah said, I am a licensed associate counselor for the state of Arizona, and my specialty is marriage counseling for couples who have children with special health care needs, chronic disabilities, things like that. Most of our kiddos have lots of resources, but there's not a lot for parents to help deal with their life and how it affects raising a child with challenges affects their marriage and their family. So as Sarah said, I do have 2 sons. We went through this process, gosh, I can't believe it, 10 years ago. Zachary just turned 28. And at that time, we knew there wasn't a gray area as far as whether we needed to have or file for guardianship, because he has profound disabilities. He's got a rare brain disorder, which includes autism and epilepsy and profound cognitive delay. He's about a 3-year-old level cognitively. So when I found out, that, okay, now I was presented with the reality that I have to now file for guardianship of my own child, it was a little overwhelming for me, to say the least. It was kind of an odd feeling of, why should I have to go to a court? He's my son. He's going to be my son forever, and so it was once again another experience in the life of raising a child with a disability that now I have to navigate. So that's what I wanted to, I really wanted to talk to, particularly those of you who are parents, just to take deep breaths and kind of take in all the information. The other presenters are will certainly give much more specific information on the process, but I wanted just to kind of touch base and talk about what the experience is like emotionally and psychologically and stressfully for those of you of parents of, wow, I don't know what to do. We went through from, depending on when your child was diagnosed, for 18 years of going through, the diagnosis and meeting with therapists and meeting with specialists and surgeries possibly and medications and IEPs and all that, and we become comfortable, at least in our world, of, okay, this is how it's been for 18 years. And then all of a sudden, once again, we are handed another new experience. What does this mean? What does it mean? What do you mean guardianship? What does that entail? What does that mean as a parent? And it can be, and it was for me personally a little overwhelming. I put on, hopefully you all see that, I figured, once again, we're all familiar with the lovely bell curve, and whether it's, what we've seen from doctors handing us, well, this is where your child is plotted on the bell curve of diagnosis, or this is where your child is plotted on the bell curve in your IEP. Well, we can plot ourselves as well as where we fit from mildly irritated to profoundly emotionally affected by the experiences we have raising a child with all the challenges that go with that. And so we can plot ourselves, just going through when we get in our own normal zone, that gray area, the light gray area, and when it says average person, I want you to look at it as the average experience of a parent who has a child with disability. Sometimes we are way far on the right, sometimes we are way far on the left, and majority of the time, through 18 years, we're kind of plotted in that middle. And so keeping that in mind of, your expectations of, now what do I expect? Some parents may be, oh, this is just one more thing that I got to do and I'm good with that. To the extreme of others like, oh my gosh, I'm feeling completely overwhelmed. I don't know who to talk to. It's just kind of like talking to doctors again of, okay, one thing I hear from one person and another person tells me another thing, and then I talk to parents, and then I just want to close the door and turn off the lights. So just be aware of where you're at and your level of anxiety or not anxiety. And what comes up a lot is, and I remind parents that grief is not linear. And what this does, this experience is, okay, here we go again. I am now faced with another reality of my life is very different. My child's adulthood is going to be very different. Those hopes and dreams, once again, that we thought we were going to have before our child was born or once they were diagnosed, the loss of that. And then that is reintroduced again with the reality of now I've got to file a legal form to be a guardian to my child, and what does that mean? Am I still a parent? And so emotions return. So just make sure you're being mindful of how you're feeling about the process, because it brings back a lot of, and it may heighten a lot of anxiety and emotion. You know, you think you've hit a lull, and now you've got to figure out, well, who do I go talk to? Like I said, the decision of guardianship wasn't difficult for us, but the process was confusing. It was confusing because we weren't sure where to go. And we decided to do it, Ray and I decided, through the self-service availability at the Superior Court. So we just did it all on our own. And you can find them online, and I'm sure the other presenters will help you, guide you through where you can find that paperwork online at the Superior Court's website. And there's quite a bit of paperwork. And I found that mostly it was, at the beginning, it was tedious, because you ought to get a lot of your child's documentation from doctors. And on a side note, if you haven't already filed for SSI, supplemental security income for your child, if they qualify, that does help if you have that in place, or in the start once you go in with the guardianship, because that kind of aids. If you know this is something that I have to do, I already have this set in place or in the works. So we went through the instructions, and that, like I said, that was kind of tedious. And then we were provided a court-appointed attorney as we got through the process, and we met with the attorney at his office, and took Zachary with us. And again, it's kind of like meeting a specialist for the first time. I'm not sure what to expect. I'm not sure what questions to ask. And he was very helpful and very understanding. And then a court date was set. And that's when it got really surreal, because now we got this court date and time, and we are to show up at the court with our son and sit in a courtroom. I had never been in a courtroom. I didn't know what to experience, much less sitting in one with our son. So my husband Ray and I are sitting on one side of the court, and my son is sitting next to his attorney on the other side of the court, sitting there, you know. Could have a care in the world. Where he's got his Thomas the Tank Engine trains and his cars, and he's sitting there at the table, and I'm sitting there looking at him, you know, about 10 feet away, and it was so surreal, and it was a bit emotional for me, because once again I was, you know, facing the reality of my life is very different. Zachary's life is very different. The court. The judge himself was a very lovely man, who he has since retired, what I had found out. And it only lasted maybe 10-15 minutes, and we went through the cursory questions that the judge asked, and the attorney made his motions, or however that is. I'm sure Jennifer will explain what that is. And then it was done. And we went back to our daily lives. Nothing really changes as far as your care for your child. It is a legal document. But what changes is now our future going forward. What that brought about emotionally and psychologically as parents was the only way I can put it is facing our own mortality and realizing, oh my gosh, firstly, I didn't think Zachary would live this long. Secondly, that now thinking beyond that and what guardianship means and what it is I'm required to do to file, in August, it's up for, my time to do the annual update of guardianship. And all the requirements of filing that documentation, making sure that we see he sees his doctors, and those asking your doctors, could you please write a letter stating that you had seen him and this is where he's at in his physical health, and that is you attach that with the guardianship paperwork. And so not only are you just doing your normal raising your child or caring for your child, you're also reminded to document, this is something that I have to do because I'm legally required to do this. It's just another kind of like a tap in your shoulder. You just remember you're a guardian now. Any paperwork you do, or a doctor's appointment you go to, we had to provide them a copy of the guardianship so we could speak to his doctors that we've spoken with for 10 to 18 years, and now we have to show them that we are legally we are legal guardians, so we can speak to them. And it just kind of it kind of goes against what we feel as parents. We're very protective of our kiddos. We're very, majority of us are very on top of caring for them and feeling very responsible for making sure our kids are safe and healthy and protected. And then now we're being, in a way it feels, now we're being asked to prove that. And it is a very odd feeling. Once again, if you go back to the bell curve, some people parents won't have any problem with this. They just kind of, those water off a back type of experience for some of you will be plotted in that light gray area of, yeah, this is really odd and it's taking a long time and this paperwork is really annoying and we got to file it, and then when we file part 1 and then we got to file part 2, and you are interrupted again with another obligation or requirement in your life that we already have a lot on our plate. I tried to work through my own emotions and with Ray of what that meant for us, as far as, okay, if going through this paperwork, it's asking us questions about guardianship, and if something was to happen to us, then we realize, do we have a will? And who would be guardianship if and when something happened to us? And then picking people beyond that. And it was it was and can be emotional for a while, because you are asked to think about those things that, when Zachary was first born, we were asking those questions. I don't even know if he's going to live. And then when we, and we've had the doctor say, yes, he's going to live, but we're not sure what quality of life. And so that was a question. Well, what do we expect his life is going to be until we then experienced it? And he is his own unique individual, and we do love him very much, and he has his amazing qualities and his challenges, and we became comfortable with that. And we hoped that he would live long, did not think he would live as long as he has. And so that brought about the reality of, okay, we are not going to live together or live forever. And what if Zachary does outlive us? And who will take care of him, and what does that mean, and will they want to, and what does that mean for his brother? I want you to be aware of and be acknowledge the feelings that brings up for you, because even though it just may be for, something that attorneys do day in or day out, or like doctors, they see how many patients day in and day out. But this is our experience, one at a time, one parent with their child, and it can be very impactful. And again, some people may already have an idea of, well, this is how it's going to be, and on that bell curve, I'm just on the lower end, and we're just going to fill out the paperwork or meet with our attorney and be done with it and move on. There are those who are on the farther scale of the bell curve. This is really overwhelming, and I'm frightened, and I don't know what this means, and what if I do it wrong, and all those feelings that come back from the first when we're first diagnosed, or the first surgery. Am I making the right decision for my child? Is this the best thing for them? Is there anyone else I can talk to that can tell me for absolutely sure that this is going to work? Those feelings return. And our brains don't know the difference between what we experienced 18 years ago or 10 years ago and the anxiety we're feeling now. All we know is it feels the same. And we don't like to feel that. We run on our norm of anxiety, that it may not be healthy, but that's our norm. And then when we add something onto it, such as the going through this process, it can sometimes affect our emotions and our anxieties exponentially. We become consumed by, did I feel that right? Did I feel that out right? Am I going to be in contempt of court? Are they going to come barging through my door because I've not filed in time? And all those things of the responsibility that we take on as being a parent. So just take a few moments and think about what it feels like when you thought, okay, I'm going to listen to this webinar. Or if you were on this morning and you're feeling, oh my gosh, I am overwhelmed with information, that you take it one day at a time and just look at it at one step at a time, and take it, even if it's, I'm going to schedule this into my day, or I'm going to get the first, because it goes in sections as far as what you file. I'm going to get one filing done at a time. I'm going to talk to the attorney if I have, one available, or if I'm having an attorney do it for me. I'm going to glean as much information as I can, so I can allay some of that anxiety with, okay, I've done everything I can, and I've done it to the best of my ability. And if I haven't done it correctly, someone will let me know, but I won't lose my child, or that sense of, my gosh, what's going to happen. I've had calls from parents of, my child is 20 years old. I had no idea that I was supposed to do this. I'm scared to death that I'm going to get in trouble. Something like that. And allaying those fears of, as long as you make the decision, if that is something that you have to do, that you get as much information either from the courts or from the attorney. I personally feel like it would be more of a challenge or an emotional experience for me had our son had mild disabilities. Zachary does not, he'll never live independently. He will never be married. He'll never vote. Not that anyone wants to right now, but he never drive. So all those were easy decisions for us. For those of you of parents for kids who have some mild, moderate disabilities, cognitive disabilities, physical disabilities, having to make that decision for them of, yes, they could live independently to some extent, but what extent does that mean? And does that, knowing that if I file for a full, guardianship, that they don't have those rights anymore as far as the right to drive or vote. And so that is what, once again, a grappling issue of what does this mean? Am I doing the right thing? Will this limit his life, his or her life? And that's something you sit down and talk through with your spouse and your physician and your attorney if you have one, and clarify for as much as you can, is this the best thing? The name of this webinar is The Last Resort. For our son, it was the only option. It was the responsible option. I can't imagine those families out there who have no idea that this is something that they had to do, and then, God forbid, something happened to them and their child is left, whether they're now a guardian of the state or they are placed with a relative or a friend who there was no other option. So preparing, kind of like when you write out a will, it is not fun, but you have this set in place. So if and when something happens, they are covered, they are cared for, and you're being the most responsible parent and the most loving parent that you can be. We go, like I said earlier, we go back to, after it's all said and done, I still go back to the daily routine of taking care of Zachary, enjoying him, being blessed by having him in our lives. We are still and always be his parents, and we are guardians legally. And when we go to doctors or meet with doctors, we take them a copy so they have that in his file. And then our lives continue. And then every year, annually, when I have to do the guardianship update, I'm reminded again that I am, I don't know what is the right word. My life is short, and I want to do the best that I can to be the most responsible parent. And I love my son dearly, and I want him safe, and I want him around people who will love him and care for him. And this is the best thing that I can do for him. So that's what I wanted to share as far as being a parent and being a psychotherapist. I've been on both sides of the couch, and I know we deal with these emotions on a daily basis. The last thing I wanted to, one of the few things, is this: we have this in common. Just like it says, what I found is the number one emotion we deal with raising a child with a disability is we feel powerless to the diagnosis and the confused, the resulting life experiences that follow. And the one thing we can't change is we can't take away what has happened to our child. We can't, when we have tried to figure out and have an answer of why did this happen, what can we do to make this disability or this health issue go away? And that always sits in the back of our mind, and it affects our decisions and our emotions and our reactions to life. And this experience of filing for guardianship or not filing for guardianship, or to whatever extent that you become legally responsible, it brings back these lingering, and our lovely friends that drive us drive with us in our cars, called Emotions, and just work through it, work through the process of it, and take some time and step away when it gets overwhelming. I thought this was great. It's certainly exactly how I felt. As I apologize for asking you to step out of your comfort zone. This was way out of my comfort zone. Like it really was a return to the day that we got the diagnosis, and I was in a whole different state of mind, and this is how it felt when I was first told, okay, now you got to become guardian, and this is what you do, and then you got to go to court. It was overwhelming, but it ended. It's kind of like getting shots. It can be kind of uncomfortable, and then you get it done, and then once a year you file. So I am very grateful that I could share, and I'm not sure how much time I have left, or if anyone's hand was raised. Maybe, I guess I'm not sure when we take questions, if we take them afterwards. But that's what I have to share, and I'm sorry if I talk too fast. I'm a fast talker. Let me know, and feel free to contact me if you want assistance in any other area regarding your emotions and you're being the best parent that you can. And I will hand it off to Jana.
Great. Thank you so much, Kelly. Thank you for, can you hear me okay? Okay, very good. Well, okay, very good. Thanks, John, for the confirmation. I wanted to just kind of, first of all, thank Kelly for her sharing in such a really personal way their family experience. Working for Raising Special Kids as the Parent Training Information Center in Arizona, we work with families every single day and helping them navigate state systems and things like that, and also helping parents that are raising children with developmental disabilities and special health care needs. And certainly this is one of those areas that our parents appreciate additional information and training about. So we really, really try to embed in every single training that we offer, making sure that we are mindful of the family experience, just like what Kelly was sharing, that if that is a decision that a family is faced with, that indeed that they do want to proceed with getting guardianship for their adult child or their child that's approaching the age of majority, then that acknowledging those feelings is a really, really important part of that, and it helps them be more effective through the process, because it is, as Kelly described, quite lengthy and tricky. And I know that Jennifer will wrap us up with some really great technical assistance in the end, with once that happens, and then what we can expect afterwards. So what I'm going to talk about today is the process. So if the family has decided, yes, this is what we need to do, then when should we start? Where do we go? How long does this take? Who can actually petition the court, and why would we even need guardianship? So those are the things that we're going to cover in our time together. I completely feel like Kelly shared the family experience in a fantastic way about the struggle that their family faced with balancing what's an appropriate amount of independence versus what's an appropriate amount of protection, and that some families it's in more of a gray area than others. So it can be a difficult decision. We also like to acknowledge that whatever decision that families choose to make is what's right for their individual family. And the other piece of that is sometimes it's difficult for us as parents. I'm a parent of an adult son with cerebral palsy, and whenever I started hearing words like incapacitated and indigent, ward, those kinds of things were really difficult on my ear as a parent. So helping parents also prepare themselves for that is an important part of that process. Once we have decided, that's usually been because we've had some professionals that we trust that have helped us raise our child, that are part of our child's team, that have indicated a real concern for their capacity to make safe decisions. Also, some of those questions are answered that we've realized that our child could be exploited by others, not necessarily misguided, but certainly exploited, and those are two entirely different things. And then if we're thinking of when can I even start the process? Well, we can't start the process until our child is 17 and a half, and that's when we can submit that first petition to the court. Even if our child is over 18, we can still petition the court after that time, but we can't do that any sooner. So the cutoff is 17 and a half, and that is whenever we can submit our first packet. That's whenever the family, the petitioners are petitioning the court for guardianship, and between that time then and the hearing date is set, a little bit of work happens. I won't get into the details of that because I believe that Jennifer is going to cover that quite nicely. So between that time and the actual hearing date, then there's a lot of work that happens between that 17 and a half and 18 time. And where do I get those forms? Kelly alluded to that earlier. We can grab those on the two ways. They can be downloaded off our county that we live in Superior Court website, or we can go down to the Superior Court and actually request the packets from the law library. Typically, they charge a small fee there to print those out for us, so you can do it either way. One of the things we like to remind families is that if they choose to download all of the paperwork off the website, to be mindful that there are instruction packets and there are form packets, and that bear in mind that it is for adult guardianship, and that also that there is a separate packet for a request for fee waivers and deferrals. And I'll spend a few minutes talking about that now. Because one of the things that we hear as a parent center so very often is that families are really worried about how much this is going to cost. And we all can agree that many times as families, even $100 is a lot to ask. So a family, when the petitioners can fill out a fee waiver and deferral packet, and they're requesting the court to consider a deferral until the determination of guardianship has been made with the possibility of a waiver. Very helpful for the families to complete ahead of time. And again, if they fill out the paperwork themselves, then there is the fee that is incurred are only the court costs and filing fees. And I believe Jennifer will cover that for us in more detail here in a moment. So when we're thinking about the different types of guardianship, as far as not even the different types, pardon me, it's more of who can file. So when we're considering if it's going to be a mom and a dad or two partners, however that looks, it's two people, two loving people can share that responsibility of being guardian and co-guardian, and they share responsibilities. It is unlike whenever the bank says 2 signatures required at the bank. This is where both can make those decisions at any point in time. But that also requires on their paperwork that both guardians fill out their information in the petitioner section. And that can be tricky because the forms only ask for one petitioner. So usually that means that we're having to squish both that information on those forms. And that many times will bring up questions. Yikes, am I doing this right or wrong? So never fear, it is like that. There's only space for one, but if there are two guardians, a guardian and a co-guardian that are necessary or that want a petition, then both their information needs to be shared in the petitioner section. And what is a successor guardian? This is a person that would serve as the guardian in the event of both the guardian and the co-guardian's death. It can be a sibling. They do have to be over 18, and the successor guardian is actually named in the guardian's will. There's not additional petition that's required at the time of the hearing to indicate a successor guardian. And once again, so something that we need to bear in mind before we go to our hearing is that now the courts will require an online training for the petitioner to complete an online training. This link is where you can access that. It's not difficult, it's not extremely time consuming, but there is a certificate that's printed out at the end once you've completed it that the judge will ask for at the hearing. And then this is just some bullets for you to kind of go through what are the steps if that is we have decided we do need a guardianship, and just to kind of help you organize your thoughts. And I loved what Kelly shared earlier about compartmentalizing. Okay, today I'm just going to do this section. Tomorrow so those are some suggestions for how we can prioritize our time whenever we're preparing to fill out our paperwork. And so before I hand it over to Jennifer, I just wanted to share one more thing. So I did include in our with our webinar, a webinar companion called Steps to Guardianship, and it's down in the bottom in the file section for you to download. It has some very helpful links on there for the Superior Court website, some other information that might be helpful to you as well. So I wanted to make sure you were aware of that. So it is my pleasure to hand this over to Jennifer Kupaszewski. I'm delighted that we get to share this time together, Jennifer.
All right, thank you so much. John, you will let me know if I can't be heard. I'm Jennifer Kupaszewski. I'm an attorney here in Arizona practicing in the area of guardianship and conservatorships. And like our other two presenters, I also have a child with a disability, a traumatic brain injury, and we faced this decision and decided not to go the guardianship route. And I'm proud to say that he just recently graduated from college. So it's a tough decision to make. We're going to focus today on once you've made the decision that this is the right legal option for your family, what is it going to mean? So what is a guardianship? At the end of the day, it's a lawsuit like any other lawsuit, and you have to comply with all of the legal terms and requirements such as notice, which we'll talk a little bit about, just like any other suit, because you're moving to take away a person's constitutional right. And that's why a guardianship is a really big deal. It's held to a higher standard than your average civil lawsuit. And that's why there's so much paperwork, and you have to present evidence, and you have to be investigated, because now you've moved, as Kelly talked about, that emotional movement from being the parent to now being the guardian. Parents have rights over their minor children, but guardians simply have duties and responsibilities to a protected person who is under the jurisdiction of the court. And the court takes that responsibility very, very seriously. So it is a huge shift for parents when a child turns 18, because at the end of the day, when they turn 18, they're an adult, regardless of how that relationship over time is developed. So who needs a guardian? It's someone who, we use terms like incapacity, and I feel Jana's pain with regard to how the law doesn't have very person-centered language. In fact, I won't use it in my PowerPoint, but the language that you will see when you look at the packets that we've talked about and the statutes is that the incapacitated or protected person is the ward. They are a ward of the court, and they are their guardian's ward, which is not a term that I like, but it is the legal terminology. It's someone who can't make decisions for themselves that are responsible or safe. And you heard both Kelly and Jenna talk about, you know, what does that mean? I mean, I have 5 kids, and every one of them, when they turned 18, needed a guardian if we were just talking about good decisions. But we're not talking about good decisions or bad decisions. We're not talking about gambling. You have the right to gamble as an adult, and you have the right to make bad decisions. As Jana mentioned, we are talking about someone who potentially may be exploited or seriously harmed because they don't understand the basics of adult decision making. So that's the potential impact on the protected person, and why you have to balance whether or not a guardianship is needed, whether or not it can be limited, because by statute it does terminate someone's driving privileges unless a physician says they can still drive. It does terminate their right to vote unless you specifically request that the court retain their right to vote, because you're hoping to maximize their independence. So you want to think about all those things. Generally speaking, it is essentially what it means to be an adult. The person doesn't have sufficient decision-making ability to contract, enter into a marriage, adoption, purchase a home, car, obtain credit. So it's an enormous imposition on the person's life, which is why you have to do all the paperwork. The paperwork is to show the court that this constitutional interference in this individual's rights as an adult are necessary. So you will have to provide significant detailed information about the person who wants to be appointed the guardian, called the petitioner, the person who would be the protected person or the ward, who is the respondent in the lawsuit. And when it talks about probate cover sheets or court investigator sheets, it really comes down to the court needs personally identifying information so that they can issue a fiduciary warrant if need be. And so we'll ask about height and hair color. So it's a tremendous imposition on both the family and the proposed protected person. And unlike when you become a parent, you have to establish that you are a fit and proper person to be appointed, and we'll have to file an affidavit to that effect. The fee waiver also is a separate application. I'm glad that Jana mentioned that there were instructions and forms. You're going to need all of those packets. Every single county has its own, in Arizona, has its own self-service center where those packets can be downloaded. And I think a pretty simple Google search would bring that up for any county that you're in. These are the steps. Step one, this is all the stuff it takes just to get into that court hearing. Step two are the things you're going to need before the court hearing. And then step three is the paperwork that you will have to bring to the court hearing in order to finalize the matter. So a whole new cast of characters will come into the family's life, into the protected person's life, to surround them to ensure that this is really the right thing to be done and that their rights are fully respected and that they are fully informed of what is being asked to be taken away from them, and that's their constitutional right to make decisions. So we'll have the court investigator. This is an independent fact finder for the court to ensure that this is not an exploitive action, to ensure that this is what's needed for the proposed protected person, to make the judge aware of any other issues. And so when Kelly said you feel like you're being asked to sort of prove it, the parent is. I mean, that's a legitimate feeling, and I work with families all the time, and it's not a good feeling. Now, when these people come out, they're trained, and they do this all the time, and I think they're generally respectful. Just the idea, though, as Kelly mentioned, is uncomfortable. Then there needs to be a physician's report. This is important, and when Janet talked about filing before they're 18, that becomes really important because you still have, as the parent, HIPAA rights, and so getting this physician's form that tells the court why a guardianship is needed is easier before the child turns 18. Because it is a court action, the protected person and other people, such as the other parent, are entitled to notice. And for older individuals, a spouse or adult children, they're entitled to notice of this action because they may also be entitled to nominate themselves as guardian. Now, how you let people know, notice is a legal term, which means you are telling people about the action. That means they have to get a copy of the petition that you filed, the paperwork, and they need to know when the hearing is. So sometimes mail is okay for certain interested persons. A process server is always required for the person whose rights you want to take away. They are entitled for the court to have an affidavit that says absolutely this person is aware that this is what you filed against them and the other spouse. So the instruction packet will inform you as to what type of notice is is necessary for who you're trying to notify of the action. And there is an acceptance and waiver in these self-service packets that you can use that would save the cost of service on some individuals, but never, never, never on the proposed protected person. And unfortunately, owl post is never an acceptable form of notice, even though it's the most fun. So going to court. This is the part that scares people. The case will be set for a permanent hearing. An emergency is something that you can request if something terrible is about to happen to the person, but that's a more complicated process that we don't have time for right now. Typically, the hearing is set about 45 days out, and it's that third set of paperwork that you need has to be delivered to the judge 5 days before, because judges like to be prepared for your matter, and they want to read it ahead of time and make sure that everything is in order. If you don't have all of your paperwork in order, you may end up with another hearing. At the hearing, because evidence is required, you will have to give some basic testimony. Essentially, it's what you put into your petition. So the guardian, the proposed guardian, must testify, but it's a very informal court, so please don't be intimidated by that. As Kelly mentioned, the proposed protected person gets an attorney, and they may assist you. That person, though, is the protected person's attorney, and that person represents them and not the guardian. So to the extent that they don't represent the petitioner, if you don't have your own attorney, you need to prepare these items yourself. You can ask for a limited guardianship, and that is assessing whether or not there's anything that the proposed protected person can retain for themselves in terms of decision making, because we want the guardianship to be as least restrictive on their life as possible for them to maintain as much independence as they can. You will read in the paperwork about a conservatorship if the person does not have more than $10,000 in an account, and that does not include Social Security, because that is managed through the representative payee system through Social Security and accounted for there. If they don't have more than $10,000 that a guardian is managing, you don't need a conservator. Being a conservator requires accounting, budgets, inventory, so don't ask for one just in case the person gets any money, because it will create a huge hassle in your life you do not need. And finally, just because the person is the guardian doesn't mean they can't move. They can move from state to state, and they can do so, and the process can be streamlined through the Uniform Guardianship Act. So I hope that information was helpful to everyone. I know we want to leave some time for questions, so I'm gonna end now and open it up for questions.
Thank you, Jennifer. It looks like we have one question in the chat area right now from Mary Ann, and she asks, how many co-guardians can you have? And then also, what happens when one either moves or passes?
This is Jennifer. So I've never seen more than 3 co-guardians just because it becomes very confusing. The co-guardians can act independently. That means that when their orders and letters are issued, you don't need all 3 co-guardians to go to the doctor's appointment to approve treatment. They can act independently. So having at least 2 guardians is nice because you have a backup. And then I see the question also asked, what happens when one either moves or passes? Again, guardianships can be transferred. To be guardian, you do not need to be in the same state in Arizona as the protected person. So it's okay. You just have to tell the court of the new address, because the court always has to be apprised of the guardian's address. And if a guardian passes, then you have to notify the court that that person has passed. You get a notice of death, and they are no longer a guardian, just so the court isn't wondering why can't I reach them. So that sort of answers the question. And then there was also, Jana talked about by will. So if the guardian passes and there's someone in the will, they may be able to step in through a more streamlined process if there was a will nominating the successor guardian.
Mary Ann says, thank you. Anyone else for questions? You can place them right in the chat area. We have one more up in the queue from James. It says, in the case of divorced parents with joint custody, should both parents be guardians?
Again, this is Jennifer. That sounds like a me question. It depends on how well the parents communicate and get along. Remember, they're not parents anymore. They're guardians with duties and responsibilities. And the entire guardianship is focused not on the guardian, but on the protected person. It is solely for their benefit. So if they get along and they can make decisions together, then co-guardianship would be ideal. There is a new statute that just passed that will go into effect next January that says that if the parents had joint legal decision making, which is what we call it here in Arizona now, there is a presumption that they could both be co-guardians and that joint decision making would continue. So just be aware there is a new statute in Arizona.
Thank you, Jennifer. Stacy asks, and James says thank you. Stacy asks, what sort of things does the investigator check?
Does either of my Jennifer, either of my co-presenters want to speak to that, or do you want me to?
I can jump on it, and Kelly may have a really great kind of insight to add to this as well. Typically, what our understanding is, and what our parents have reported, is that when the investigator comes, they come to the home, they meet the young adult, they meet the family. Sometimes they want to go and visit them at their school, or if they're participating in a day program, or if they have a job. It's usually a visit where they come and they talk and see what the natural settings look like. It's their, just like what Jennifer said earlier, it's their responsibility just to kind of check things out a little bit.
Yeah, this is Kelly. That's about what it was. It wasn't anything overly intimidating. The person was very friendly and just wanted some information, and actually to see that, you know, I got the feeling that I just want to make sure you're telling us the truth, and that's a good thing.
Yeah, and this is Jennifer. So I want to disabuse anyone of the notion that they are going to come in and investigate the home and open your cupboards or anything like that. It's definitely more in the vein of what Kelly and Jana just described, that they're checking in, eyes and ears of the court, just letting the court know objectively, this is a good thing. Yes, what they pled is true and accurate. So it's not an investigation in the sense of like a Child Protective Services investigation. It's not in that same nature.
We have a couple more minutes for questions. If there's anyone out there that wants to put a question in the chat area, we can go from there. All right. Marianne asks, when parents age and need to hand over guardianship, is it hard to get it transferred to a sibling or other family member?
This is Jennifer. So we don't have a statute in which you can transfer guardianship per se, and we don't have standby guardians. So it would involve the current guardian nominating a new guardian, to step into their shoes. So is it hard? It's not as hard as the initial petition because a lot of the work is done, but it's not something that you could do without going to court. It will still require a court hearing, still require that they demonstrate that they're an appropriate person. So and there's no standby.
Stacy asks, what if there isn't anyone who can take care of your child in case you pass away?
Can I jump on this one? This is Jana. Typically, one of the things that we talk with families about, Stacy, is that when we're thinking about people that help us raise our kids, it's the people that's within that you really do life with. And sometimes that means looking even outside of our immediate family. Sometimes those are trusted friends that you've chosen to be a part of your life. And they are perhaps raising a family alongside you, and they share the same the same priorities and things that your family embraces in your own community. So sometimes we really help families to think outside of their own biological families and think about friends, trusted friends that could possibly stand in a case like that. And my understanding, Jennifer, I'd love it if you'd kind of touch on this after, is that if there isn't anyone, and there is a determination that the person does indeed need a guardian, then there would be a public or private fiduciary would be appointed for them.
Yeah. So just quickly, if there is no one else, then a private fiduciary could be appointed if there are funds to pay that individual. If there are no funds, there is a county public fiduciary in every county in Arizona.
Thank you, Jana and Jennifer. We have one last question. Is the yearly validation to the court of doctor's visits, medical expenses, housing expenses, and general well-being presented to court on the anniversary month, or do they send a notice to appear in court, or is the guardian responsible for scheduling the court appearance?
Kelly, I would love it if you would answer
Kelly.
your experience. Yeah.
Sure. And I'm getting close to that. It's typically, like, our annual date is August 17th. So I usually get the annual update of guardianship in within that week, within a couple of days. And all you do is bring a copy you attach a copy of the letter from the doctors with that annual update, and it can be just a very basic. This is when I saw your the individual. This is their medical state of health at this time, and the date that I saw them. I didn't have to, or we don't have to attach medical expenses or housing expenses. It just asks very basic information. When was the last time you saw your child? Well, I see him every day. My husband and I just recently placed Zachary in an adult developmental home, which was that could be another whole webinar. But we see him every other week, and so we would put that as far as this is when we see him, listing the names of the physicians. Any other information on the intake or the update is what other services do they receive? Do they get respite, attendant care, habilitation? Do they attend a day program that asks for the names of those places? But you don't have it's not asking for any detailed medical or housing expenses or anything like that. It's very easy, and you fill it in. It takes about a minute and a half to go down. Once you're at the court, file it. Make sure you make as many copies as you need to, whether it goes to the other important people in their lives that need a copy of that update. And you go in, and the court, they stamp it, and you're off. It's very, very quick.
And this is Jennifer. The only time there's a court appearance is if you don't file it.
Yes.
Well, this is John. I want to thank our presenters very much. Thank you, Kelly. Thank you, Jana. Thank you, Jennifer. I want to remind everyone that if at all possible, please go to the link in the chat area and evaluate our webinar. We do value your feedback, and we hope to sort of move those comments into future webinars. That's it for today. If there are any questions, please contact us through whatever avenue, through ADVPC or IHD, and we will connect you with whoever you'd like to talk to. Thank you again.
Thank you, everyone. This is Sarah. We really appreciate your participation today. I'm going to attach the link here in the chat box to, once again, our Legal Options Manual. It's a workbook available online for free at our website. You can print that out. You'll find fillable forms in there that really highlight some of these terms around guardianship in plain language if you need a refresher. We'll also have these 2 webinars recorded so you can share them online with family and friends on our website. We typically get them up within a week, so keep an eye out for those in your inboxes. And if you'd like to join our mailing list, just send me a message. Let me know here in the chat and we'll get that worked out. Thank you once again, everyone.